Perjury charges were lodged against her by the organisation Accountability Now in relation to her findings in 2017 about the Reserve Bank during the creation of ABSA in the 1990s. Those findings were overturned by the Constitutional Court, who found she had not told the truth in her investigation. The head of Accountability Now is Advocate Paul Hoffman. Paul, good afternoon to you. Start us at the beginning here. Why did you lodge these charges against Busisiwe Mkhwebane?
Well, it was really simply a matter, Stephen, of following through on findings that had been made by the Constitutional Court in the appeal. Well, in fact, it was the consolidated appeal of ABSA Bank and the Reserve Bank against the remedial action that Advocate Mkhwebane had ordered against them. You'll remember that the Reserve Bank was going to be turned into a vehicle of state capture. ABSA Bank was ordered to pay back, I think it was 3.2 billion rand that had been advanced by the Reserve Bank to predecessor banks back in the dying days of apartheid. So the finding of perjury by the majority in the Constitutional Court triggered our complaint to the Hawks. It also impelled us to take the matter up with the Legal Practice Council, because Advocate Mkhwebane is an officer of the court, and officers of the court are not meant to sit around with perjury findings against them. And we took the matter up with Parliament again, because we'd already complained to Parliament back in January 2017 about suspicions of her mendacity and her incompetence just a couple of months into the term of office. And then finally, we took the matter up with the President, who has a discretion to suspend the Public Protector or any other head of a Chapter 9 institution while removal proceedings are pending in Parliament. As you know, there are removal proceedings pending in Parliament against Advocate Mkhwebane, and we have today renewed that request with the presidency.
So, I mean, if what you say is correct, then you base this entirely on the findings of the Constitutional Court. The findings of the Constitutional Court are binding. There's no one to appeal to after that. I mean, it would seem to me quite a difficult space for her. There's no argument. There's nowhere to go and argue.
What you need to remember is that the finding that was made in the Constitutional Court was made in the context of civil proceedings involving the Public Protector, and that the onus of proof in civil proceedings is on a balance of probabilities. What has happened in the Hawks investigation of the perjury findings is that the Hawks have been able to find sufficient proof to put the prosecution service into a position to establish beyond a reasonable doubt that there was perjury, and that being the test in a criminal case has led to the preparation of a charge sheet and an appearance in the criminal courts next month by Advocate Mkhwebane in the dock.
There's a very strange set of circumstances that were happening in 2017. So Jacob Zuma was still president. The Guptas, we now know, were moving large amounts of money out of the country, I mean, very large amounts of money. If I remember correctly, she actually and her staff held a meeting with the State Security Agency while they were finishing this investigation. There was a strange moment where someone wrote down, how are they vulnerable in relation to the Reserve Bank? I mean, what was really going on here, Paul, do you know?
Well, I think that the greatest mistake that Jacob Zuma ever made from his own point of view was to appoint Thuli Madonsela as the public protector before Mkhwebane. And the greatest mistake he made for the public of South Africa was to appoint Advocate Mkhwebane as the successor to Thuli Madonsela. You'll remember that everybody thought that recently retired Justice Siraj Desai was going to be our new public protector in October 2018. That is not how it panned out. And it seems clear now that Advocate Mkhwebane is the corrective action after the mistake made by appointing an independent and impartial and integrity-filled public protector called Thuli Madonsela. And what we have with Mkhwebane is simply a Zuma deployee, and that was the vulnerability they were looking into.
Okay, it's quite a strong comment to make. Do you think Parliament is going to remove her? I mean, she has said that she believes she will finish her term.
Yes, she thinks she will finish her term on the basis of a Stalingrad strategy, and we all know who has invented that strategy, South African litigation. Her plan is to attack and review and appeal and delay all attempts to get the parliamentary process finality and to a vote on whether or not she should be removed. And if she uses every stratagem available to a recalcitrant litigant, then she is in a position to stretch that litigation up until fairly close to the end of her term, which is only a 7-year term, which started in October 2016. So do the math. The difficulty that she now faces, because the Hawks have done what they've chosen to do, is that should spur the Legal Practice Council into actually getting on with the striking off application. And if she is struck off, that's the end of it. She cannot be the public protector if she's not an advocate. So that creates a whole new dynamic in the matter. And also, in the criminal proceedings, her opportunities for delay will revolve around a request that the decision to prosecute her be reconsidered, the refusal to reconsider be taken on review, the review be taken on appeal, and so on and so forth. So we've always taken the attitude at Accountability Now that a multi-pronged approach is required. The sadness about this is that if in January 2017, the Parliamentary Portfolio Committee on Justice had said to her, "Madam, you've been asked 13 questions about your incompetence and your dishonesty. Will you please answer the 13 questions properly and fully?" If that had been done, a lot of public money would not have been wasted, a lot of heartache would have been spared, and a lot of work for courts would not have happened, because she would not have been in a position to order inappropriate remedial action when the law requires her to order appropriate remedial action.
Paul Hoffman, Advocate Paul Hoffman, I do appreciate the time from Accountability Now. Thank you very much indeed.